Okay, good morning, everybody. Welcome to our FDEA Exporter Operations webinar this morning. We're delighted to be joined by Rowena Tully and Alicia Nash from Kilburn and Strode, one of our export service provider members, and they're going to be talking to you this morning about brand protection in global markets. I think we are joined by a couple of FHC exhibitors in China, which is happening next month. So welcome to you. And yeah, just a few housekeeping sort of rules. We've got a chat function here. So if you do have any questions, ladies, as they go through their presentation, just please pop them in the chat box and we'll come back to you after the presentation during a Q&A, and you have a chance to ask them any questions that you might have as we go along. Just to let you know that this is being recorded, so we will send a recording of the webinar after the event, and we'll also pop it on the members portal for those of you that are FDA members, so you can access at any time. Okay, so I'm just going to hand over now to the ladies who are going to talk about the brand protection.
Wonderful, thank you very much. Right, I'm going to share my screen. Hopefully I'm showing the right thing here. Right, does that look like an opening slide to everybody?
Yeah.
Wonderful. Thank you very much. That's a good start. So hello, everyone. Welcome to you all. Thank you for coming along to the webinar today, and obviously to the FDA for inviting us to speak. Some of you may know us already. We're members of the FDEA, and you might have seen us on other calls or events. Hopefully we'll see some more people as well in person at the event in December for the FDA Awards. So hopefully, as Mel said, you've all come to listen to a talk about trademarks and brand protection today. Do dial off if you're expecting something more exciting like learning how to windsurf or something. Before we dive in, just a quick intro to us and our firm. I'm Rowena, I'm a partner in the trademark group and I lead the firm's food and drink team. My colleague Alicia is one of our associates, also in the food and drink group and in the trademark team, and has lots of clients in the sector. For those of you who don't know us so well, our firm is called Kilburn and Strode. We're a UK and European intellectual property firm. Our home is in London, in Holborn, but we've also got offices in the Netherlands and a liaison office in San Francisco. And we're one of the few IP firms to be top ranked for both trademarks and patents in the 4 leading legal directories, including Legal 500. We work with companies of all sizes, startups through to multinationals and everything in between, including, you'll be pleased to hear, lots in the food and drink space. It's a sector actually we especially love. It's lots going on, lots of innovation, great people, and as long as we do a good job, we normally get some pretty good client samples as well. To give you a flavour of the food and drink brands that our attorneys have worked with, here are some of their logos on the screen for you. You'll see it's very much across the food and drink spectrum in terms of size, age, products, and so on. The nature of our work, of course, differs according to the client, but fundamentally, we're offering strategic business advice on how to protect key assets. Part of that is, of course, filing trademarks, patents and designs in the UK and around the world. In fact, some of the portfolios we handle are 80 countries or more, so we really get around a bit. But the more strategic part of our role, I guess, is the running of portfolio audits, rolling out IP strategies, running clearance checks, fighting IP disputes, handling anti-counterfeiting matters, domain name, company name disputes, and so on. So basically, if it's to do with IP, it's very much our bag. Before we get going on trademarks, I wanted to touch just very briefly on patents. Patent protection is, of course, really important for some food and drink companies, especially when you're looking at methods of manufacture, new ingredients, and so on. But I think for most companies here today, probably trademarks and designs are more relevant, so that's going to be what we're focusing on. That said, if you've got any specific patent-related questions, please do follow up with Alicia or me. You've got our emails there, and we'll be very happy to help. We've got a whole host of patent colleagues also with lots of food and drink experience. So what are we going to look at today? We've got about half an hour, I think, with time for questions afterwards. So this is really a very whistle-stop tour of brand protection for food and drink exporters. We thought we'd cover some of the biggest topics that come up when we're working with food and drink companies, which you can see here. As Mel said, please do post any questions in the chat box and we'll get to those either as we go or at the end. And as I say, you've got our email, so please do drop us a line. We'd love to follow up afterwards. So, but before we dive into the nitty-gritty of today's webinar, I wanted to take just a quick step back and ask more fundamentally, why should you even bother with trademark protection? And the answer is in one of my favorite quotes, which you can see there. If this business were to split up, I'd be glad to take the brands, trademarks, and goodwill, and you could have all the bricks and mortar, and I would fare better than you. And that's from John Stewart, former chairman of Quaker Oats. For most food and drink businesses, the most important asset they have is their brand. It's not the factories, it's not the recipes. The brand is really what customers grow to know and love, and that's what keeps them coming back for more. So the trademark protection is really the means by which you're protecting that brand and goodwill. Unpicking that just a little bit, in practical terms, protecting your brand by filing trademarks is going to add value to your business. If you're looking for exit, any purchaser is going to want to see really robust trademark protection in place, since that's essentially what they're buying. You might want to call it an insurance policy for the brand, I guess. According to one international brewer we were speaking to a while ago, they were saying that a lack of trademark protection is one of the biggest headaches they have when they're looking at whether or not to buy a craft beer brand. And the same really goes throughout the food and drink industry. Any gaps or risks on the IP front are almost certainly going to come out during the inevitable due diligence process at key milestones like investment and exit, when you've got lawyers like Alicia and me poring over your portfolio, trying to pick holes in it, and provide reasons why somebody might want to lower the price or pull out of a deal. So what you're really aiming for then is a nice strong portfolio which gives investors or purchasers the confidence about your IP position, how you manage risk, and about your company in general. Even if you don't have any major milestones coming up, trademark protection is also still really important, of course. It protects your sales growth and reduces the chances of disruption to your business, both at home and abroad. You'll get much stronger protection by registering your marks in terms of blocking other marks coming along which are too close, stopping competitors using something that's too close, whether it's accidental or sometimes, unfortunately, otherwise. Basically, it reduces your risk of a dispute and puts you in a much stronger position if there is one. I think it's also worth flagging that some countries like China in particular, they don't provide any protection at all based on the fact you've been using the mark. These are what you might have heard called first to file countries. So if you don't register, somebody else can steal the mark on you, get their own registration, and then stop you selling, even if you've been selling for years, which is obviously a slightly large headache at that point. So that's really just a little bit about the why before we get going. Next, we wanted to talk to you about filing strategy. Clearly, you can't register all of your brands and trademarks everywhere, or it's going to cost you a small or a big fortune. So how do you go about prioritizing, and what should you be thinking about most? I'm going to hand you over to Alicia for this bit.
Thank you. So when it comes to registering your brand, it's very common for businesses to think about IP and trademarks in a vacuum, but it's actually really important to marry up your IP strategy with your business strategy, and a joined up approach between your legal, marketing, and business leaders can ensure you make the right decisions and get it right. As having a clear strategy and knowing what you need and where you want to protect it can give you focus. There are so many export opportunities available to food and drink suppliers out there. So it's really important not to get distracted and to focus your brand protection efforts on the countries where you're likely to see the biggest rewards. So sales, or where you're likely to see the greatest risk, so from squatting and so on. When thinking about trademarks, you need to think about not only where your business is now, but also where you want to be in, say, 5 years' time. And that means thinking about what names you want to use in the next 5 years, the countries, and also the products you want to offer within the next 5 years. So looking at this kind of little image on the right-hand side of your screens, hopefully, the first thing you want to think about is what brand you're actually using. So are you using a word mark, or are you using logos? And if you are using a logo, are you using it in a specific color? So purple, for example. This can be extremely important in terms of use requirements, as once your trademark registration is more than 3 or 5 years old, depending on the country, there are different rules in different territories, it can be cancelled for what's called non-use if you can't show that you've used your mark as registered. So for example, if you've registered in purple, but you're only using it in red, for example, you may lose your trademark registration if you can't prove that use. Next up, working our way around the circle, you also have to think about where you are selling, and as I mentioned a moment ago, where you plan to export to in the future. So it's good to think about this early so that you don't run into any issues and have to rebrand down the line and end up using different brands in different countries, which frankly can lead to a lot of unnecessary faff and costs in terms of packaging, marketing, your social media, and so on. There are also different filing routes available, and some of which can be more cost effective than others. So you've got the international application, which is often cheaper if you're filing in multiple territories at once. And you've also got EU trademarks, which cover the 27 post-Brexit, the 27 territories of the EU. So importantly, that's the European Union and not other countries such as Norway, Switzerland, or the UK. But it's important to know that there are some drawbacks to these systems. So just make sure to discuss the options and make a clear plan with your trademark attorneys of which route you plan to take early on. Then lastly, we need to look at what products you are selling now and what products you plan to sell in the future. So all goods and services or products are split into 45 trademark classes, and only a handful of these are relevant to the food and drink industry, but ultimately it's your specification and what you list in your application when filing that determines the scope of your protection. So for example, you might think you need just one class for your drinks brand, but if you plan to sell different types of drinks, so say for example, you only sell drinks now, but you plan, if everything goes well, you might plan to sell non-alcoholic drinks in 2 years' time. You'd actually need 2 separate classes, as alcoholic cocktails and non-alcoholic cocktails fall into 2 separate classes. Thinking about this early can save you costs, as you can't expand your list of goods after filing. So if you include everything you want to use within the next 5 years at the beginning, that can save you having to file a whole set of new applications when you do expand your product ranges. So whilst there's no set formula for getting your IP strategy right, and obviously each business and each food and drink company is unique, marrying up your particular business's commercial aims and IP strategy early on, focused, stay on track, and get the best return for your IP spend. We've been working with a client on this recently, actually, and working closely with a drinks brand who have used our BrandsFit tool to help form their IP strategy. So we asked them a whole series of questions about their business and their export plans and came up with a detailed IP strategy, which we're now rolling out. We've got a separate info pack on BrandFit. So if you think this might be of interest to you, just let Ro or me know and we can ping that to you later on. So the next step, once you've worked out what you want to register and where you want to sell, the next question is, can you? So a big part of what we do as trademark attorneys is running clearance searches to check whether a third party owns any earlier registered rights which you may infringe, which could stop you registering your mark, and worst case, an infringement could result in product recall and stop you from being able to sell in that particular country where they own those earlier rights. A common misconception is that having your trademark registered in a given country means that you're free to sell product there, but it doesn't. So as a trademark is a negative right, so it doesn't actually give you the right to sell anything. It only gives you the right to stop others from using or registering a trademark that is too close to yours. That's why searches are key in making sure that you're able to use your brand before you launch there. And as with your IP strategy, there's no one-size-fits-all approach to searching, and what level of searching a business conducts depends on their attitude to risk, the importance of the product, their commitment to the mark, how much of a pain it would be if you had to rebrand down the line, and perhaps what tends to be the most deciding factor, cost. It's also worth bearing the specific market in mind when thinking about which countries you want to search in. So for example, some countries are more litigious than others. Japan tends to be less litigious and we see less trademark disputes in Japan, whereas the US tends to be more litigious. So you want to tailor your searching strategy by country and tailor where you spend your money. So it may be more important to search in the US, for example, and worth spending there. On a more general note, we wanted to touch on some of the biggest mistakes that we often see. So the first is not running any searches at all, or not running the right kinds of searches. So there are various levels of searches available, looking at both identical and similar marks, and looking at both registered and unregistered rights. And which you proceed with is a balancing act based on the factors I mentioned a moment ago. But the key thing to understand is that there are differences in the searches available, and to realise that checking on Google, the company's house register, isn't enough and doesn't give you the full picture of what's out there and what other parties are doing and own. The second is only searching in your home market. So for example, only searching in the UK, and then thinking that because you have a registered UK trademark and have been using in the UK, you're free to sell your product abroad. Just like when coming up with your trademark strategy, when running searches, it's really important to look ahead and to think about what markets you plan to expand to in the future. We actually recently worked with a food and drink brand that originally started abroad and then launched in the UK, only to find that there was a third party who had already registered and been using a highly similar brand here. They're now having to rebrand and use different packaging and marketing materials in the UK, and running the right searches in their key markets where they plan to expand to early on would have saved some headaches on this front. Another common mistake that we see is brand owners thinking that only identical marks are an issue. As Ro mentioned earlier, even when there's no identity, if marks are close enough to be confused, there can also be a risk of infringement. So with that in mind, please note that if you add an extra descriptive term, so for example, if you came across the Innocent brand and you do ice cream, not drinks, adding ice cream after Innocent, so Innocent ice cream, that would not be enough to avoid confusion. There's still similarity there.
Thanks, Alicia. Not surprisingly, China is one of the topics we get asked about most often, and we thought that no talk on trademarks and exporting would be complete without talking about China. It's obviously a massive market, huge potential, especially with the rise of the middle classes and the change in consumer tastes, for example, a much greater interest in dairy. But also much greater potential to get it wrong. So rule number one is that normal rules do not apply in China. If you're doing business in China already, you've probably already found that things work just a little bit differently there, and the same goes for trademarks. There are strange quirks, things to trip you up, and getting local advice, and indeed good local advice, is absolutely key. And just to give you an example, Alicia was talking earlier on about the 45 different classes of product and service, some of which are relevant to food and drink. Those 45 classes are internationally recognized, but just to be different, China also has a subclass system which sits underneath each class, and this really affects the finding of whether marks and products are found similar or not. So for example, you find that tea in China is deemed not similar to tea-based beverages because they're in a different subclass. Likewise, sugar is deemed similar to chewing gum, which wouldn't be in the UK, but sugar cubes are not similar to chewing gum. And again, it's all down to which subclass they sit in. So it's really important that you make sure the right subclasses are covered in your applications, both in terms of making sure that you've got broad enough protection, but also from an from an infringement perspective. So, for example, on a UK reading of a Chinese registration, you think, oh, okay, no infringement risk, we're absolutely fine. But actually, under Chinese practice, the situation might be very different. Another key point we wanted to flag for China is get your registration certificates. Lots of companies file in China using the international trademark system, which Alicia mentioned, and that's almost always better than filing separate national applications because it tends to be cheaper. But if you go down that route, you'll only get a simple letter saying that your mark is protected in China. It's not the same as a registration certificate, and you will need the certificate both if you're going to enforce your rights against anyone else, but also some online marketplaces require you to have a registration certificate that you can submit to them to list your products. And it can take some months to get these certificates through. So basically the rule is as soon as you get confirmation that your mark is protected in China, make a separate application to get the certificate. Another thing to mention is geographical names. These are a common problem in China. geographical names often feature quite commonly in food and drink brands, but marks containing these names are generally prohibited from both use and registration in China for a whole bunch of different legal rules, which I won't bore you with. There are a few exceptions: state names, state-level new districts and major developments, key state projects, some mountains, rivers, and tourist attractions. But all of those also come with caveats. So again, it's really, if you've got a geographical reference in your name, it's really worth getting advice early on before you go into China. And then China, squatting. So yeah, no talk on China would be complete without mentioning squatting. It is still a huge problem. There have been big improvements over the last few years. There's always new laws and things coming in, so that's promising. And I think the authorities do recognise what an issue it is. But you know, you're not out of the woods yet. We still see people trawling through the UK trademark register and registering up Western brands. And what's interesting is actually not always, or indeed often, the most famous brands. It can often be SME level brands. So no one is safe, if you want to say that. So if you are going into China at some point, file now. As I mentioned before, it's a first to file country, and save yourself the headache and expense of finding you've got a trademark squatter that you need to deal with later on. A few years ago, actually, I worked with a client who had to pay a squatter £20,000 to get their brand back, and it was a massive panic because it all came up during due diligence prior to an AIM listing, which is really absolutely what you do not want to be dealing with. What else on China? Yeah, Chinese characters marks. So if China's a key market for you, have a think about how your brand is going to be used by the local population. Would it be worth protecting a Chinese character equivalent before the squatters register, for example? There's two main ways of doing this. One is a transliteration, where you have Chinese words which sound the same as your Western brand but mean something different if you read the actual kind of meaning of the Chinese characters, or a translation, and that's where the mark actually sounds different when you pronounce the Chinese characters, but the meaning is the same. And again, getting local advice on what options are available, what would work best, is really important. And then the last point to mention really is that China is obviously huge and a massive market, but a Chinese registration only covers mainland China. It doesn't cover Hong Kong, Macau, or Taiwan. So if those are important markets for you, you'll need separate trademark registration for those. We've actually got a one-pager of top tips for brand protection in Asia. We'll circulate that, I think, afterwards. Mel, I think, is going to send that around for us. But otherwise, please ping Alicia or me an email and we can send that to you as well. Following on from China, another topic we get asked about commonly is rogue distributors. It's all well and good when relationships and sales are going well, but that's really the time to make sure that your position is strong in case anything changes in the future. There's really a few ways to do that. A couple of them are here. First of all, own your brand. And what do I mean by that? Well, make sure that your trademarks are filed and make sure that they're filed in your name. You'd be surprised how often we see distributors doing it for you, but somehow never get around to assigning the marks to you. They really have you over a barrel in that situation, especially if you want to change distributors in the future. And this kind of no register point applies not just to trademarks, but also domain names, company names, and so on. And we see all of those being filed by distributors. Quite apart from controlling your registrations, you really need to beef up your contracts as well. So in the event of a problem, you're not looking just at trademark infringement, but also breach of contract. And actually, that can sometimes be an easier thing to enforce than trademark infringement, especially in countries where either you haven't filed trademarks yet, or they're only pending but not yet registered. We recommend checking that your contracts set out a list of all your marks. They could be registered, unregistered, words, logos, imagery, and so on, but just make really clear in your contracts that those are property of you. Also suggesting clauses where the distributors agree not to file applications for your marks. And again, that's not just trademarks, but also domains, company names, and so on, and that they agree not to use your IP without your consent. Lastly, be crystal clear on what happens when the contract ends within the contract. Who can use what names for how long, what property reverts to whom. And I do appreciate that depending on the size of the distributor, you may have more or less input or control over what goes into the contract. Certainly with some of the big retailers, it's pretty much my way or the highway with contracts. But wherever you can, try and get these clauses in and keep them in mind. I wanted to touch on social media accounts specifically, as it came up in the FDEA WhatsApp chat not too long ago. I'd suggest that you add the setting up of social media accounts to things that distributors can't do without your consent in your contracts, if possible. Or if it's absolutely critical that distributors set them up, because they're, I guess, the experts in the local area sometimes, you could at least say that these accounts are always subject to your review or approval, and or that they have to surrender or transfer them to you at the termination of the agreement. And maintaining control of what the brand looks like and how it's used is also really important. And that's both from the consistency of your own branding, of course, but also to go guard against the non-use issues, which Alicia mentioned earlier. She was talking about that if you've got a logo mark, it needs to be used as the registration shows, otherwise it could be cancelled for non-use down the line. And as part of that, obliging distributors to follow any brand guidelines that you've got can be really helpful. And again, lock as much of this down in your contract as you can. And just a final point, remember this applies not just to distributors, of course, but any other business partners. So have a look at your contracts with manufacturing partners, JV partners, licensees, and even employees, actually.
So following on from that, another thing we wanted to touch on was the importance of locking down the ownership of your logos or other design works. If you can, I'd appreciate some reactions on this next question. I'm not sure if you've all got the ability to use the reaction tool, so you can wave if that's easier. But how many people here today have had logos or packaging designed by a design agency? I can't actually see anybody. I can't scroll down there, but lots of our clients have, and it's important to remember that when you are contracting with design agencies, that unless you agree otherwise, the copyright and the logos that they design for you will actually belong to the designer or the design agency and not to you. So it's really important to make sure that you have a copyright assignment in place to make sure that you own your brand. This is actually one of the things we see most commonly forgotten when running our brand fit reviews. And even some of the biggest brands get this wrong. You may remember in the early 2010s that the Innocent Drinks brand was in the news regarding the ownership of the copyright in their Dude logo. So the logo had been designed by a design agency who later tried to invalidate Innocent's EU trademark registration for the Dude logo on the basis that they actually owned the copyright, not Innocent. There was an agreement between the parties, but the agreement had never been signed. And this resulted in years of litigation and uncertainty for Innocent. And although the judge ultimately did find Innocent to be the owner of the copyright in the Dude logo, this was an entirely avoidable, and I'm assuming very expensive mistake. And as Ro mentioned, this is not the kind of thing that you want to be coming up in a due diligence exercise. So just one to bear in mind. We also wanted to quickly mention registered designs, as these are also often forgotten about or thought about too late. Designs protect the appearance of the whole or part of a product, and as a result, they can be a great way to protect the look and feel of a product or packaging and can be a useful defense against copycats. So in order to obtain a registered design, unlike trademarks, which can be filed whenever you like, you can't have disclosed your design prior to filing. There are certain grace periods available in some countries, but not all. So, for example, not in China. But we just wanted to flag them to you so that you're aware of them. You might have missed the boat with your current packaging, but it might be an option for rebranding in the future, so worth keeping in mind.
Thanks for this. Yeah. So what would we like you to take away from today? Number one, you can't register everything everywhere, and you really don't need to. So get advice on the best strategy and prioritization to make your budget work as effectively as possible. We do a lot of this work with our clients, and the outcome is a million times more strategic and more focused than the usual kind of reactive scattergun approach. Remember also that your business and exports evolve often very quickly. So don't assume that just because you filed a bunch of trademarks, 5 years ago, you never need to look at trademarks again. The priorities of your company change, your logos change, products change, and your trademark portfolio needs to evolve as well to support that. second point, in case we haven't stressed it enough, another key takeaway is the importance of good communication, and that's really both externally and internally. It's really important you share your business plans with your trademark attorneys and check in with them regularly to make sure that they're giving you the best advice and steer. If you're working with attorneys who haven't already asked you about your export priorities or where the business is heading, then make sure you tell them what you're doing. Internally as well, really important to be joined up. And it's crucial that the way the trademarks are handled really reflects what's going on the export ground, as it were. Don't let trademarks be handled by somebody too junior as a purely administrative thing with no oversight. In terms of who should actually handle the trademarks in your company, it really doesn't matter. It could be the head of international, head of marketing, finance director. We work with all kinds of different people in our clients. As I say, it doesn't really matter as long as there's a joined up approach and a really good coordination with the export business with whoever's handling the trademarks. Third point to take away is think holistically. It's not just about filing trademarks. As Alicia mentioned, registering designs can also be a really powerful way of consolidating your position and protecting your brand. But also make sure that your contracts are working for you as hard as they can. And actually remember, they could be the strongest weapon if there's any kind of falling out. Fourth point, are we on four? Yes, 4, China. A little test for you here. I don't know how good your Chinese is. Mine's pretty ropey. But according to the Chinese attorneys we work with, they've told me that this, I'm pretty sure this is equivalent to the early bird catches the worm in Chinese. Or as they say in China, the bird that wakes up the earliest has the best chance of catching the worm. So just remember, China's a huge opportunity, but you do need to act early and get good advice to reduce the chance of a big expensive headache. And remember to get your certificates. And lastly, just remember, this is not just another tick box exercise. You're protecting what is potentially the most important asset in your business. So do get good advice and allocate the time, budget, and internal resource it deserves. So I think that brings us to the end of our whistle-stop tour. We might be 2 minutes over. I hope that's all right. I think we've still got a bit of time for questions, and I think some questions have actually popped up. I'm going to stop sharing. I can see everyone again.
Yeah, thanks, Ro and Alicia. Yeah, there was a question regarding, could this also apply to certain ingredients? Whoever wrote that question, they just want to unmute yourself and
yeah, sorry, that was from me. This is Nick from Tyrrell's, by the way. Yeah, so you mentioned about the protection of your packaging, your logos, and but I think we've had an experience whereby we've used a seasoning house and they blended a seasoning for us, but it's under their IP, so we've not been able to sort of declare the absolute ingredients, or they won't give us the absolute ingredients. Sure. So I'm guessing that would be the same process, really, isn't it?
Yeah, that's right. So I mean, ingredients and recipes usually can't be protected by copyright. Usually they're protected by know-how. So you don't register it anyway, you just keep it as a kind of trade secret, essentially lock it down by non-disclosure agreements and so on. And if you're working with third parties, it's then just a negotiation as to whether you're going to own the rights to that particular bit of know-how or whether they are going to.
I think we've experienced in certain markets where we try to enter, whereby the like Korea, for example, they want to know the absolute ins and outs of all the ingredients you have. So if you have got a seasoning, then what is that seasoning comprising of, and almost what percentage splits. And sometimes we're not able to get that.
Yeah. And that's a tricky one. I think labeling generally is obviously it's going to depend hugely on the country, but but you're right. If it's a trade secret of somebody else, then that's more difficult for you. I guess it's a question of what level of detail do they need? Is it the actual number of ingredients, the proportions of the ingredients, or is it just, it's got salt, pepper, I'm being simplistic here, but is it just salt, pepper, rosemary, or is it, X percent of salt, X percent of pepper, and X percent of rosemary? That's something that perhaps the people that you're working with aren't able to supply. But as ever with these things, the more IP that you can own yourselves rather than having to license or use somebody else's, the better. Does that answer your question a little bit, Nick?
Yeah, it does. Yeah, it does.
Yeah.
But has anybody else got any questions? If you do, just unmute yourself and you can ask away. Yeah, one of the things I just wondered, you obviously touched on China, and you did say that you don't have to protect your brand everywhere. I just wondered what other sort of key markets where across the world where you really should be thinking that this is what we need to do.
Sure. I guess normally, if we're talking to a UK business, you start with the UK, you do some checks in the UK. I mean, obviously, it's a more established brand. You've been there for a long time anyway. But I would say that the countries that we see most is the US, just because of the sheer size of the market. Although, as Alicia said, it's pretty litigious. So you want to make sure that you know you're safe to go in there. And one company we're talking to at the moment actually is they've recognized that the US is such a big project that it's almost a project in its own right. They don't want to dabble. They only want to go in there when they're really ready to do that. They're thinking about setting up a separate US entity to kind of protect their UK business if it all goes wrong. So people treat the US slightly differently, but I'd say, yeah, US huge, EU huge, even post Brexit. And we saw this in the FDEA slides over the summer. Europe is still, the EU is still really important for UK businesses, and a single EU trademark can cover, as you said, all 27 countries in one go. So that's a really good one. Just with the EU, be careful though, because you might, as Alicia said, you might assume that because you've got an EU trademark registration, you're safe to sell your product anywhere in Europe, but you could be infringing any number of other EU trademarks, or indeed like a national German registration or a national French registration, which is why these checks are so important. So yeah, EU, US, China, of course. Australia, actually, we see as quite a big one for food and drink exports. I've worked previously a lot with Premier Foods, and they did a huge amount of exporting to Australia. The only thing to be aware of is sometimes if you've got one of these historical brands, you find there's split ownership, that perhaps the rights to a particular brand were sold for only certain territories, and then the new owner thinks, oh, brilliant, let's start exporting to XYZ countries, only to find that this historic brand is now owned by somebody else in these other territories, which can be a bit of a pain.
Any other questions for the...
Hi, I got a question.
Hi, Fan. Yeah, go ahead.
Hi. So thank you so much for the talk. Very informative. And we do have these sort of questions currently. I'm from Other Foods, and we are trying to sell into the US market. And we realized that there is another company registered, Other Foods, in the US, and they are selling baking mix. That company has gone bankrupt. So, but there's no way that they're going to sell that trademark. They still have the ownership of that trademark. So our distributor recommend us just register something different. So we decided to register Other Foods & Co. So do you think it's a good strategy to just use Other Foods & Co. from now on across all the different markets, or should I just still keep Other Foods for the UK and EU market and then treat US market as a complete different entity?
So there's lots of bits to unpick in that, Fan, actually. So thank you for the question.
Right.
I think the first point, I wasn't sure if you were talking about registering this as a company name or as a trademark, the bit & Co.
It's the trademark, yes.
Yeah. So Alicia was giving the example, I think, of innocent ice cream earlier on. Just adding & Co at the end absolutely doesn't take you away from this other foods mark. Yeah, other foods. They're still too close. So adding, if they chose to object, then they would still win. Just adding & Co makes no difference at all to the risk of confusion by consumers. So I think your distributor might be slightly wrong on that point. Right. If they're talking about registering a company name, that might be different, but certainly in the UK, as long as the company name is not absolutely identical to another one, you can still register it, but that doesn't mean to say you're then safe to use the mark, the name as trading it under it in the UK. So I don't think that's a solution. Having said that, at least in the UK, if a company goes bust and their trademark is still sitting on the register, the ownership of that trademark then reverts to the Crown, and it becomes what's called bona vacantia, and you can actually sometimes try and purchase that from the Crown. I don't know off the top of my head what happens to US property belonging to a US company, but I guess there's the kind of the legal risk. The mark is still sitting there. Could somebody own the rights to it? The second point is the practical consideration of how likely are they really to cause a problem if they've gone bust? Are they going to have the resources to actually challenge you anyway? So I think there's two aspects. One is, are you going to be sued by them? Probably not if they've gone bust, depending on if the business got sold before that. And the second point is that trademark going to block you on the US register? And all the time it's sitting there, it's going to block you whether or not you put & Co or not, but you might be able to cancel them for non-use or some other kind of cancellation option. It's the third point I think you made was you know, should you use that same brand everywhere afterwards? And actually, we've got a company, exactly the one that Alicia mentioned, the one was a foreign company that's come into the UK and has now got this issue. They're rebranding in the UK, and they're now thinking that actually they're going to roll out the rebrand of the UK retrospectively almost to the other countries where they started, so they have the same brand everywhere. And for a food and drink brand, especially nowadays, it's so international and social media is so international. I think if you can possibly have the same brand everywhere, it's much, much easier for you. It's just, as I say, the caveat in this particular case is whether ANCO really helps you. It probably doesn't. But if you'd like some advice on it, do ping us an email, Fan. We'd love to have a look into it for you and get some advice from local attorneys for you.
Yes, thank you. I will drop you an email after this. Thank you so much.
Yeah, please do, no problem at all. Just a matter of interest, actually, you mentioned my work. I'd love to know if people could just put quickly like what their main export markets are. I would say the ones that we were thinking of are the ones that we see most commonly, but it would be great to know if actually what you're doing reflects what our experience is as well.
Right, so currently we export to some of the EU countries such as Finland, France, Germany, Portugal, Estonia, and then Middle East, we export to Dubai in conversation with Saudi Arabia. And then we started to do this test run in the US. Yeah, that's the current markets that we're covering.
Yeah, the Middle East actually is one, sorry, I should have mentioned actually, and Alicia was talking about which kind of marks cover a bunch of countries in one go. There is a UAE registration. It's not like Dubai and then Abu Dhabi or whatever else. So you can get a single registration which covers you for the whole of the UAE. It's not a cheap market to register actually for trademarks, but it's quite effective if you can get a registration. It covers quite a broad area.
I see. I will drop an email after this.
Please do, Fan.
Yeah,
Absolutely.
thank you so much.
Any other questions? No, it looks like
everyone's experts in trademarks now.
Yeah. Just to say that Kilburn and Strode will actually be attending our event on the 5th of December, where we will actually have an export power hour. So this will be your opportunity to go and, you know, ask some questions one-to-one. So do come along if you haven't booked tickets. That's the FDEA Export Forum and Awards. Let me just have a look what's come in the chat. Yeah, I'll be sending out their email addresses on the email afterwards with the recording, fans. So yeah, please do get in touch with them afterwards. Yeah, I think that's it then. So thank you all for joining, and do take a look at our FDEA events page for upcoming webinars on different topics on our export operations feature. Yeah, always welcome to join, and yeah, we hope you found this morning informative.
Thanks very much for having us. Have a lovely day, everyone.
Yeah, thank you.
See you soon.
Thank you. Bye.
Bye.